since up to 30th November, but not yet listed. So, hello.
Eight is a lot. But I beg to mention item number 43, Lord. All of a sudden it has come like it has been parted before a lot.
All methods comes for us all of a sudden. 60 methods are listed in the cause list on all of a sudden.
I cannot. Can
Is
I
that
take
it?
next Thursday, my lord? I
The
have
Learned
taken the
Council
consent
for the appeal and praise for an adjournment. Full stop.
on 29th, my
Huh?
29th.
Accordingly, matter is released from part R and be listed in the part 2
Malad,
hearing.
Malad,
Let it remain in part one, my lord. It is hard in length, my lord. Only nuances needs to be filed, my lord.
my lord, I'll take
And
only 10 minutes to my lord.
Only
Otherwise, my lord,
Do it 10 minutes today.
only rely
some difficulty today, my lord. That's why, my lord.
only
Lordship,
rely
kindly we kept it as parted, my lord, because otherwise it also.
Before vacation, it's not possible, and we cannot keep a method part have more than 1 month. That is simple. It will come back here. You will wear it.
Can we?
It's not permissible beyond 1 month. And before vacation, hearing a matter, ignoring all these bail methods, it's not possible. And that it's a matter of 2017. Many methods happened. We have given you a preference on that day because you said that the man is in the
Yes, yes.
it's less. That's why I given you a preference. Okay. Yes, next case.
May I please your lord? Let it be kept at parted, my lord. Date is your lordship's prerogative.
We cannot keep it as part hard. If it comes back because we cannot keep beyond 1 month as a method part hard. That is the notification.
Can it be on this?
Tell us, see the people are waiting to move
29.
unlisted methods for bail.
29.
Someday first week of
December.
May I please your lord?
First week of December.
Yep.
We'll see, we do not know.
Only if the
We have no case.
I'll
Rely.
anyway, blood, whatever
We
we
have
let
no
it be
case.
disposed of, blood. That I'll
That
persuade you.
day we could have because we gave you
No,
a
no,
chance.
but the other anyway, man.
May I please, your lord?
Yes.
I beg to mention one anticipatory bail application which
I
was,
told you, anticipatory bail.
lordship, this is a exceptional case. What happened, lordship? The first
Oh,
one,
just wait, give a minute to express.
yes,
All the cases AB and BA pertaining to these bands stands allowed. This is the standing yesterday. Devi, I'm sitting for almost a week.
specific direction is required because what happened for last 4-5 days, it is in defective. The person is in leave, and now it is pending, lordship. That's why I mentioned it. Obliged, lord.
Please, Lord. I have to mention that item number 57.
Mm.
Lord, the documents will require some time.
Where are the
Well, I have informed. In fact, they do not have any objection.
okay. On the prayer of Mr. The matter says adjourn and be listed in the first week of January.
I recommend item
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 40.
49. Hearing
Yes.
adjourn for a day.
What is the total sentence?
I'm not prepared.
Why this matter is listed in the part 1 hearing list to 2023? We'll fix it in the part 2. Let this matter is, we'll pass it on.
Public.
May I please?
Yes.
I think to mention for listing of criminal petition for 2018 case. Also compromise there.
Next week, give it. Musumi, give dates. 6th, put it 6th. 6th of December.
On review petition, and for the respondent. Otherwise, the matter was 6 last on 26 night 2023.
Review by this order passed by this court.
Yes.
Next December. Give it. 1st of December.
May I please, your lordship? Yesterday I have mentioned it, so refixing the method, and your lordship suggested me to discuss it with the learner. Lordship, I have already discussed with them. The method may be come up on 1st of December. Lordship.
1st of December.
Okay.
And otherwise, this matter is fixed on?
6th. Lord.
Okay, 1st of December. What about? This is a matter, I think. So he sees.
Lordship. Obliged.
Have the instruction on that. Yes.
Lordship, I beg to mention item number 28 of daily list, did not.
Yes,
28, my lord, case.
any interim?
Maybe.
Interim is there. When? What about?
My lord, on 18th of December.
18th of December. Interim to
Published.
complete.
Your Lordship, I beg to mention in this IA criminal on 4th December.
What criminal for what
For
purpose?
condone criminal representation.
Condonation of
Condemn-
delay. Notice has been issued. Other side appeared. Notice served. Are you sure? Be sure.
We have taken step.
No, you have taken step is a different aspect and notice served is a different aspect. Whether notice is served.
We have on last.
Oh, you have taken steps.
Step.
Whether notice is served. You are not aware.
No.
So don't make a mention. Get the information proper. The notice is served, it can be taken up, we'll allow it. Yes, next case.
May I please, your lord?
Yes.
I beg to mention number item 46.
Hmm.
In case council is the empowerment is on the pilot. That is why I pray for adjournment for that.
Wait, we'll adjourn, we'll give accommodate, let the matter reach. Okay?
Yes, sir.
Yes.
Please, take the
Item number? It's a bail application, charge sheet file. We'll call for the scan copies.
NCB is there. Madam.
Huh?
We are not able, appearing NCB.
So NCB's name is not shown. List this matter.
Yes,
showing-
NCB is shown, my lord.
Item number 5.
Name.
Let matter reach.
Yes.
Yes. Will be a step forward. Let this matter reach. Without your senior, you be here. And read the file. Yes, next.
Lord. I pray for listing of a criminal petition, my lord.
Hmm.
Come up for admission hearing on Thursday, my lord.
What is the petition about?
Petition is about the passing of an FIR
Hmm.
regarding this, my lord. My lord will be aware that arrests were carried out in the last year about that irregularities in the circle office. That-
Is there any stay?
No change, sir.
We'll take up when? 5th of December. Obliged.
Criminal appeal.
Hmm.
And on 10 November.
Already admitted?
No.
First time. Not in admitted, criminal appeal. Yes. Give it. 1st of December.
May I please, your lordship? Lordship,
Yes.
I'm praying for listing of the criminal revision
We have admission order.
orders, lord.
What kind of orders are you expecting? Why you need to be listed in order?
Lordship, we have certain say order passed by the category of that lordship,
Other side appeared.
not appeared, lordship, we done
Notice served.
as per my information.
No, not information as per the record office note. Notice served. Your information will not do. Your client will saying that notice has been served. Have you gone through the record? Then you make a mention after having this information. Yes.
Your Lordship, I beg to mention criminal petition.
Hmm.
For listing.
Why you want to get it listed?
Your Lordship, the matter was last year on 27/10/2020.
What is the stage?
Your Lordship,
Notice issued. Notice
notice
served.
has been issued and other
Notice-
side also
Notice served.
Yes.
Other side appeared.
appeared.
What is the subject matter?
Your Lordship, it is all about maintenance of a divorce Muslim.
You are for the wife or the husband?
Fear for the wife.
You are for the respondent.
That's one. Your Lordship, the matter may be
Give it
listed
a
on
question.
7/12/2020.
7 till.
Published.
Prepare for a criminal
Hmm.
for admission.
Hmm.
We have to tell in the proceeding of difficult.
Hmm.
Near that.
Your husband or wife?
Husband.
Husband. Wife is served. Notice served upon the wife. Not aware. Go and get it proper information. Next case. Yes, Musari.
I don't, I cancelled for discussing that with hearing.
Hearing inside
In-
or outside?
in-
What is the sentence?
The 10 years of rigorous
10 years. How many days you are inside?
more than 5
Yes. Yes, give a date mostly. 5th of December.
paper listing of with
Not tomorrow. Tomorrow is Friday. Monday. Monday is holiday. Okay, Friday.
Oh, withdrawal.
Withdrawal. Tomorrow. 20. Okay. Yes.
So 1 and 2, my lord, section 302 is
But I think there are some other methods in
Tomorrow it is fixed.
tomorrow fixed.
Yes,
We'll,
number 24.
we'll take it.
Yes.
Item number 1 and 2.
1 and
Lease this method tomorrow, and another method is there somewhere. PK Kolita.
yes, item number 1. I'm for the item number.
Item number 1.
Yes,
Okay.
for
Item
one.
number 1 and 2. Release this method tomorrow. Tomorrow. You just make a mention which are the items tomorrow. Will not pass in error.
Item number 24.
Okay. You just make him.
Yes, okay.
Pathakur, if
Yes.
possible, have the city. We have rejected the case the second
Yes.
time.
yes.
Some
18
we,
days, my lord.
huh?
18 days.
Otherwise, that's why we have fixed it tomorrow, the other case.
Okay.
If the CD is there, we can have the satisfaction. Otherwise, also we might.
Lord.
Highly.
Can copy CD and record. Huh? Hey, this is CD. Scan copy of the case diary and record. Give a date. Possible. From which place? 1st of December. We'll 21st. Okay, 21st is good.
This is the city may be called from notice
C-
to the informant.
CD and notice to the informant.
Can I take the Dusty mail
Dusty permitted. Pathakur, when?
from customer of Borpeta?
My lord, on 8/12.
Can you keep the 7 page?
Yes, my lord.
7.
I'll leave.
File an affidavit, but after
Fine.
that.
I'll leave.
Yes, scan copy. NDPS 23 of 2023. Case number 25. I marked the flag. NDPS pending before which court?
before the section court,
Special court. NDPS.
NCB. And
This is pending before
section court of Amingao.
Sessions Court and
Lordship may call for scan copy.
we have called. Okay. Give a date. 20. Yes.
Much of
CD solicited.
No, your lord. 27 days.
CD
Not notice.
notice to the Dusty.
Inform.
Possible Dusty.
Regular.
If regular service, you'll have to wait for some period.
8/12.
8/12. How many days? 8/11. To be there for some years. CD when?
Actual bike already recovered the recovered the
Let police not search for another bike. Let them be busy with some other work for that time being. Yes, when what about
On my lord, 11/12.
11?
Everyone. 4:30. Take it to
CD.
48 days.
Yes, next.
yes.
Nunmati or something like that.
11, 12.
Today is 83 days.
CD.
83 days.
83 days.
Huh?
Today is 83 days, my
Then, my lord.
Notice my
83 days. Yes, whatever, have the instruction.
Yes, my lord. On
Have the instruction, see in case there is file,
Yeah,
search is filed or not.
that too, my lord.
That too. Let us have the case diary, if possible, have the instruction whether search sheet is filed, if not filed, can they produce the case diary tomorrow?
Yes, my lord.
Even if scan copies.
Yes.
83 days.
Yes.
Yes, we'll see that. We have that instruction. Yes, this is item number
10.
10. Short sheeted case, my lord.
search sheet is case. Scan.
Friday comments when they appeared before the court, they were
14 and 10 years. We do not know, but we'll see.
And
Scan copies. Child of prayer. Special case number 68 of 2020. See page 10, huh? Case diary of the record as well as scan copies of the record and case diary. We'll see.
published.
Give a date. 20.
Yes, my lord, with all respect.
We'll examine.
But can I just press 2 lines, my lord? They cannot keep like this is illegal, my lord. How can they cyber crime, my lord? There is a cyber police station. They have registered a case. And so far as we are concerned, although they inserted 90 days, that was eliminated. Prior to 60 days, on 54th day, we are granted the privilege of bail.
Okay.
And there are of this High Court, my lord, that Sheikh Abdullah case, drawing a parallel from there, my lord. If there is to be shown as arrested in any other case, here not any other case, my lord. Same FIR, same content, my lord, at a different police station by the cyber police station IO himself, my lord. I'm just, they cannot do
What
that.
you say? This is not a new case.
My lord, on the same subject matter, I was exactly same allegation, we are granted bail.
The same buildings where this offense happened.
What, my lord,
Yes.
allegation, it cannot be anything. We are employees, my lord. They are against the owners. Kindly see, my lord. First FIR, my lord, with all
Yes.
respect, my lord. Lordship, would kindly have a look at the first FIR. Go. Cybercrime, my lord. With all respect, my lord.
Page.
Page 23.
This FIR was lodged by whom?
My lord.
Inspector crime.
Inspector of Police Crime Bar.
Cyber police station.
Same now the second case we are shown arrested by the same man at Dispur police station. Can it happen, my lord?
This
Same-
FIR was lodged.
My lord. On 14/9/23, my lord. First FIR. This FIR, my lord. Here we have been granted the privilege of bail. Can I come to the bail order, my lord? And the date. That is it, my lord, with all respect, my lord. Page 32. Sorry, my lord. Page 51, my lord. It
Yes.
begins from page 50, page 51, my lord. Order dated, this is very important, my lord. 8/11/23.
Yes. Then where is the now FIR?
Now present FIR, my lord.
Huh?
By another man from Cyber Police Station,
Where is
page
that?
18.
Huh?
Page 18. Kindly see the informant, my lord. Past 3 paragraphs are ditto same, my lord. Only words are different, my lord. Some words here and there, and it is lodged by Inspector of Police Crime Branch, same police station. So as to prolong our detention, my lord. Second affair on the same subject matter, my lord. If it is read in totality, absolutely the same. And all offences are, my lord, when the special law is applicable, my lord, are bailable. And to that effect, apex court is clear. When IPX sections are there, my lord, IPC sections cannot prevail.
Yes,
My lord, at least, my lord, tomorrow, my lord, I also take instruction.
today, at 2.
Today,
That's good.
highly,
Have your instruction.
highly.
Please,
Yes, why are you here?
my lord, for 38 bail application matter.
Huh?
For
Your name?
No, my lord, I'm not a named
So
accused.
then why? That's why
My
why are you
lord,
here?
My wife is a, my lord, elected member of the Kampong Panchayat matter. So, my lord, in the allegation, my lord, kindly see page 12, my lord, sir, FIR.
Page 12.
My lord.
Yes.
May I read, my lord?
No, so what is the relevance here?
Relevance, my lord, nothing. Just because my wife is an elected member.
Do you get that your wife is a elected member? Is your wife an accused?
No, my lord, the elected body. Here the mention that the fund is separated by the beneficiaries themselves.
Your wife is not having any apprehension.
No, my lord.
If your wife is not
My-
having any apprehension, why are you having
My
apprehension?
police
Tell us that.
police visited my house and asked me to.
Police visited your house to arrest your wife, might be. She is not having apprehension.
My-
Allegation is against you, her. What is your apprehension? Tell us.
Asked me to come to the.
Go.
My lord. So, my lord, that is
Go.
the problem. Otherwise, my lord.
See, your wife is not apprehending arrest. A specific allegation against the committee where she is a member. And you say, because I am husband, I may be
my lord,
arrested.
it is mentioned that elected member also, my lord, in the party in the.
Yes,
my lord.
Pora sir, have instruction.
South Salmara.
Hmm.
Some protection may be given. My lord. Accused number 1 was arrested. He is the main accused, my lord.
You have instruction at 2.
My lord, kindly.
At 2. Why these people are coming to the court, we do not know. You
Thank
have
you,
instruction whether you require. If you require him, then we'll just give an protection and go and you give the CD. You see why these people you are after these people. If his wife is not apprehending, why should he apprehend? Tell us. We'll have to satisfy that.
My lord,
Without apprehension, we will not
Because in the-
give
the-
any
the-
intent.
the
It
elected-
should not be a routine manner.
elected body of the, my lord.
Oh, understand. Your elected body member is not apprehending
My
arrest. And her husband is apprehending arrest.
Something is done.
You might be the main man taking advantage of your wife's position. Who knows? Why are you apprehending?
Let them talk.
Tell us.
Highly obliged, your lord.
Item?
Yeah, Lord.
Yes.
My lordship, kindly peruse the page number 9. Annex 110. Translated type of it.
CD interim. Appear before the IOP intended. This is a case for absolute bail.
By the
Huh? He attained majority 4 years back.
Yes.
Not 4 years, 14, 15,
14.
8 years back.
8 years.
14.
Her abortion was last year, so after prior to 3 months.
Yes.
And now see that she has been raped during her minority and POCSO is registered. This is a case to be allowed on the day 1. You appear and give your statement.
Please. My lord,
Yes.
petitioner before a lordship is my lord journalist of a local news channel.
Hmm.
Your Lordship, kindly page 12, it is the FI.
Hmm.
The whole allegation is against one Zahirul Islam.
Hmm.
He has made some financial transaction and crores, according to this, my lord, crores of rupees has been deposited to his account. Account number has been also specifically mentioned. This is, I am nowhere, my lord, connecting, but my name in paragraph 2, my lord.
I've seen that.
Satyam. And in paragraph 5, my lord, I have stated, my lord, why, my lord, page 4 of my petition. Why all these things?
Who is this informant?
Mitu Das, he is inspector, sub inspector.
CD.
2 crore, more than 2 crore rupees.
CDC.
My lord, protection may be given. Your Lordship, kindly for a moment peruse paragraph 5. What I have stated. Why my name is there?
Okay. Paragraph
5 of my petition, page 4. I was there. This is an admitted fact.
You accidentally meet Zahirul in the hotel. Very good. CD.
Interim protection matter.
4th of December.
4th of December.
I'm okay.
Yes.
That's fine. But the book is 8 minutes. And the particular is 6 minutes.
Yes.
8 12 minutes.
So merciless to have beaten your wife.
So there-
Huh?
in
It's
fact,
so,
my lord,
in view of such serious allegation, can we grant you a bail?
in fact, my lord,
325.
We are between.
Huh?
there is no lawsuit filed after
No, we'll
finishing
have
the
to see
civil-
whether there was
after finishing
bleeding.
the
She had
civil-
got injury in her abdomen.
after finishing the civil lawsuit file, nothing in the medical report because my lord, it is her, my lord, all everything has been documented by her. In fact, for there is a report to pending, my lord.
No, that will not give you permission to beat her like this.
No, I did not go to her place, my lord. She came, my lord, and when I was treating a patient, my lord, she came and my lord,
I do not think the petitioner, other petitioner is your patient. She is not your patient. They would not have joined together to come to the court. She is not your patient. Her allegation is correct. Yes, but have the city.
Gopur.
Yes.
7th.
Earliest. We'll see that.
It's a government servant. The only
Government servants should behave like a government servant.
It's the only doctor in the area.
Gopur 4th.
Only doctor is doctor.
Doctor is what allegation is.
Is it a way to behave, expected behavior of a
If
doctor?
the facts are true, my lord, then my lord, it's not acceptable. But it is for the matter.
Okay, interim.
Then interim same 50 to 53 same. Then 16th of December.
15th of December. API before the IO and give
Challenge
statement.
of the New Year. The bank-
No,
I
not
need
New Year,
getting
not
the-
New Year, not New Year. We
Then after
want
20
us, no, New Year.
21st.
We are giving you a space for this period. Let us see.
20
Only because that 12.
Okay.
Only on the last submission that he is a doctor, government doctor, he might have a requirement of the general public to that much. We'll see
Okay.
if there is anything, injury and all, will not. Yes, next.
Okay.
Okay.
Page 37. Is the high
Where is the salary certificate? See, where is your salary certificate?
My lord, I have submitted everything.
Show us in this proceeding. You made a mention so urgently yesterday, we have given you permission. And if you please show me the salary certificate. So that we can come to a conclusion that he is wrong.
My salary certificate is not denied by the.
No, what is the amount in the salary certificate? That is very important. Do you think that there is no relevance of the amount?
It is.
There is a relevance of the amount. There is, you need a salary certificate. Because whether in the default you can
मतलब the bail amount is मतलब is 1 lakh.
1 lakh. So 1 lakh is he made a mention yesterday that
Yes, yes.
it
मतलब
was not granted. But 1 lakh, at least annual salary should be 1 lakh.
Annual salary is more than 1 lakh.
So where is that? We'll come to a conclusion. Show me the salary certificate so that I can come to a conclusion that learned sessions is committed wrong. Show me that salary certificate.
My lord, day after tomorrow, I can everything.
See, for you a person is now behind bar. You annex the bail bond. Everything is annexed that this is salary that you have not annexed. How can we have a satisfaction?
In bail bond, my lord, salary slip is annexed in bail bond, my. This is mentioned.
Understand.
mentioned here.
But is it not necessary for this court to look
This is right,
into
this is right.
that the learned court has committed mistake? This is his salary certificate, his annual income is this much. So would not have rejected on the ground that his monthly salary is not 1 lakh. See,
Yeah.
the learned council is permitted to file an additional affidavit. And to bring on record the salary certificate produced before the learned court below. But you'll have to have a salary certificate produced before the learned court, not new things. You'll have to have a certified copy of that.
Certified.
Yes. We will have to make a decision on the basis of the salary certificate, which was according to has been rejected by the session judge. How do you know that the same salary certificate was before the court to find a fault with the learned trial court? Day after tomorrow may not be possible. It will be on Tuesday. Tuesday, you have it in the meantime.
Okay.
Tuesday or Wednesday. Tuesday also, they are also holidays.
Day holiday.
Wednesday. File it on Wednesday, make a mention.
Apply.
Wednesday.
Oh no, 29.
29.
Item number 14, first sheet submitted.
Being?
First sheet submitted.
Being? First sheet number?
First sheet number 161, oblique 23, dated 21/11/23.
23. मैं फाइल अप्लाई खाली है दुनिया का ना दुनिया का बोला है dispose of IA. What is this IA?
15 also, my lord, first sheet submitted.
IA dispose of.
My item number 14, my lord.
I
am there, my lord.
So
this is the certificate submitted.
May
I pray, my lord, that the LCR may be called for, my lord.
No.
Tribal act before.
Not possess NDPS.
NDPS, my lord.
Small offenses, it is a different thing. NDPS not. Let you have the satisfaction of the learned trial court, then you come back if you are not there.
But
okay.
It 15.
Item yes.
15 also, my lord, first sheet submitted.
Being searched.
CS number 221/23, dated 20/11/23.
All right.
My lord, 16 may kindly be taken for 55, my lord.
That method, okay.
The 16 to 55 will
That we will take to the other method at bail hearing.
At 2,
Wait, we do not know. Yesterday we finished by 12:30.
as the last time.
As the last day.
As the last.
The two cases are supposed to be heard together, but in one case, in 16 minutes, CD not received. 55 minutes. 55 on that day, CD received. But since it is 6 for today.
Let it start. We'll see. We'll see whether you require, because suppose you have time to investigate, you have time to examine. If you are sleeping and suddenly you rise up and say, no, now we need him for this. He's in your custody. You
Yes.
can have his thoroughly. Yes.
Last time.
May I please, Lord? Item number 17, Lord.
17 also, my lord, circuit submitted, my
Charges have been
case
linked.
number, case number 237/23, dated 20/11/20. 18, my lord, city receipt, my lord.
Yes, Mr. Mohanto.
My lord, I am in jail for 72 days because of the business rivalry. Your lordship kindly see the FIR, madam. 72 days I am in jail. Your lordship statement goes to page 15, madam.
Yes, give me the city.
Yes, your lordship may kindly peruse, my lord, 164
And this, my lord,
statement
before
of
that, I am
the
going
mother
to
of the victim and 2 victims, my lord, minor victim, my lord. Their birth certificate is also available. Your lordship may kindly peruse 164 statement. First is, my lord, one mother of the victim, and second and third is, my lord, 2 victims, my lord. Minor victim, 13 years.
Yes.
My lord, already statutory period is over, my lord. Your lordship kindly say I am in jail in 72 days, my lord. That statutory is, my lord, 60 days, my lord. So for
What?
this concern.
Probably, my lord, section 8, not cooperating with the investigation, not appearing.
Yes.
For my section, they went there. There are 2 cases, lordship. In one case, FR Sabra, in that case also they appeared. If they, lordship, did not appear in this case, police certainly would have
There are
arrested
3,
them,
4
lordship.
cases pending.
I have interim order is there in.
You file an affidavit
Yes.
that you have appeared.
But tomorrow, lordship may take up.
Tomorrow, no, it's on Tuesday. Tuesday. Please this matter on Tuesday. In the meantime, Mr. Ahmed shall file an affidavit stating that he has appeared before the IO for recording of the pursuant to the interim order dated Spencer. Yes.
Item 20, my lord, case diary not available. Case diary not received.
Interim to continue, case diary not received. When?
On my lord, 1912,
Deeply apply.
Please, Your Lordship, I am on interim in this case.
CD is there, Mr. Bhatta.
The CD we have just received.
Hmm.
It seems final he appeared in court.
What is the allegation?
First, may kindly peruse the FIR. Please proceed. Yes, sir.
Consider the material available. That petitioner cooperate. Kali digital na? Interim order made it. Kali not there.
Yes, sir.
Yes. Where is the affair?
Page number that.
Well, here practice submission.
Any interim?
Interim was there, madam.
Interim was there?
Okay.
Okay. Dispose of.
Circuit
Circuit
number
being?
123/23, dated 8/8.
Nita. This will be interim to continue till someone receives that order. 20?
May I please, Your Lordship?
Yes.
23 also circuit
My
submission.
lord, I am on interim, my lord.
Okay. Same. Being
35/23,
dated.
dated 31/8/23.
My lord, hello.
Diploma?
24 and 25 are the arising out of the same FIR.
24, 25 different. That is something different. No, not 24. What is the item with 1 and 2, Mr. Tomorrow, that is tomorrow, 24 of tomorrow's list. Not today.
24,
Yes.
24 and 20.
Item number 1 and 2, Your Lordship has only picked along with item number 24.
24 of tomorrow's list,
Tomorrow's
not
list.
today's list. See thought that is today's list.
No,
24 and 25 arising out of the same FIR, my lord.
Hmm.
We are on an interim, but
my lord, in this case, item number 24 and 25, my lord.
Hmm.
My lord, I will get the instruction after some time regarding filing of.
no, my lord, there are the orders, my lord, where the charges has been filed. Charges has been filed, my lord.
Any
and,
interim?
both are in interim, my lord.
Interim.
Yes.
The next date, which has been is fixed on 18th of December.
Hmm.
18th of
Hmm,
December.
appear and
Appearance, because the date has been fixed for the another district.
Huh?
The 18th of
We are providing like this.
my lord.
This interim will continue till you receive an invitation from this court and you appear.
My lord.
Then you file an application.
Right.
This is the order.
My lord.
24, 25. Dispose. See the disorder.
Was stated by the Thane public prosecutor itself.
আমি লিখে এটা ইন্টারভিউ এরেকশন আর ইন্টারভিউ yes
My lord.
26 also started submitted.
yes same order
Granted interim, my lord, and
being
CS number 156/23 dated 19/9/23. 27, my lord, case diary not received.
interim is there
I'm on interim.
when
On my lord, 21/12.
21 Interim to continue.
Twenty-nine, my lord, charge sheet submitted.
Being
CS number 121/23 dated 30/9/23.
interim is there.
No interim.
Huh? No, there is an interim. Interim is there.
Yes.
Secretary Belmari, we are not in interim.
Yeah,
Yeah, my
what
lord,
about-
chairman and secretary of the my lord Tombai Shumiti. Your lordship will find the allegation, page 11.
Mm.
This is my relevant part, my lord.
Mm.
Page 11, my lord, second paragraph.
Mm.
May I read, my?
Yes.
During inquiry, office and godown of MS such and such was found open. The secretary, office assistant, and other staff of the society were found present, but the chairman of the society was found absent. Meanwhile, I interacted with the secretary, office assistant, and other staff, as well as BOD, members of the society regarding the current status of functioning and maintenance of distribution of PTS commodities, as well as supply chain management system and involvement with the present process of streamlining the PTS network and its importance. In course of verification, we observed that the secretary and the office staff have failed to maintain history as well as mandatory instruction and guidelines. These daily stock and price code conspicuously in office come business premises, etc. Also fail to produce, maintain and update daily stock and sale book of PTS, TPDS commodities instantly at the time of verification. Besides, the secretary was kept his custody 9 numbers of monthly quota lifting endorsement book of agent under such and such. Now the conclusion your lordship will find, after all these things they have mentioned, page 14.
No, please read the next paragraph. That is important. Earlier things are procedural that you have not.
It is to be mentioned that secretary has declared and displayed on such and such daily stock and price of such and such rice such and such quintal and atta such and such quintal. On physical verification, we have found total of 124.18 quintal of atta instead of 126. That means, my lord,
2.25 quintals.
Yeah.
That is 200 plus 200 and odd kgs.
And 3.56 quintal of NSP scheme rice found short. Now, your lordship kindly peruse the page 14, their findings.
Page
14. Again, second paragraph. Nevertheless,
Where?
page 14, 14.
Just a minute.
Fourth paragraph.
Just a minute. Yes, paragraph.
Page 14, my lord.
Moreover,
Nevertheless,
nevertheless,
in the middle. Nevertheless, there is a reason to believe that the secretary and chairman have misappropriated total number of substances. So, this is only on the basis of presumption.
Not may kindly
it is there.
it is there. In the basis of the inquiry conducted by my lord superintendent of my lord food and civil supply, my lord, these allegations are my lord level. My lord may kindly see page 13, my lord FIR, my lord. Specifically, my lord, what my lord may kindly see fourth paragraph regarding
Also, the secretary had received.
also the secretary had received total of 39,185 quintals, and their misappropriation is my lord 23,180 quintals. That is regarding my lord PMGAY quota, my lord. three types of misappropriation is there. One is PMGAY,
One is
another is-
APA,
another second paragraph,
APA,
MDM right, in MDM right, and third in ASEAN Commission.
Agent Commission.
Yes, this one. And this is and the inquiry report is here, which reveals that that he has misappropriated and some and also the irregularities are also found in the maintaining the society. And another,
Irregularities maintaining society is fine. You
Yes.
can, you have many
Yes.
power under Cooperative
Yes.
Societies Act. That is not an issue.
and
Issue is that misappropriation.
misappropriation.
But you don't have the confidence.
Yeah.
You don't have the confidence that they have actually misappropriated.
No, they have misappropriated. That investigation is going on because after the verification of the register and the lifting and
Therefore, for the time being, you let them appear, give their explanation.
We will produce all
I have-
necessary.
Please,
that I
please,
will-
let him their explanation,
Well-
and we'll send back the case diary.
that,
Get up to date.
that is what I'm submitting.
In the
One-
meantime, they will record their statement. We'll consider on the next date what the materials collected.
Yes, then another thing I want to submit, 41 notices were issued,
Hmm.
and they have appeared once.
And then,
That is
so therefore,
but as per his they have not revealed everything, so they are
you
they
will
are-
be at liberty to interrogate them. If
Interview-
come back us that they are not doing, we may think over what to do.
What?
Keep protect them.
second time 41
Okay.
they
Ha, ha.
it
Ah.
is
They may be fear of police, they may not go. We are protecting them. Go there and come back with your updated case diary.
that is
Then it will help you also.
yes, sir.
If
Yes.
serious materials are there,
Yes.
they have been failed, what are the
Yes.
question? Let us see their explanation.
Along with all documents,
Okay.
because the contention of the the
Ah.
IO is that they have not submitted any documents.
So you go and do that. You'll have to give this explanation.
Right,
On the
right.
next date, we'll have to see in your
Right.
statement that how you have any supporting
Right,
document.
right.
That whether you have paid the agent
Agent commission,
commission, whether why this shortage of rice.
Right.
You'll have to
MDM
be-
right,
There's all these shortage, and because otherwise they will definitely presume that you have misappropriated.
Right.
And these are meant for individual. They have a calculation.
Yeah.
There are 100 people said there are 5 kg, so this is. So if
That is India's way,
that is supplied to you,
Right.
and if you are not doing this, where this rice is gone.
Right.
So that you will have to explain.
We will.
Hard Mr. Spencer, also the case diary is produced and same is produced. Considering the nature of allegation and material so far related, material so far collected, this court is of the opinion that interim protection be granted to the petitioners to have their statement recorded by the police in as much as they earlier appeared before the IO after receiving notice under section 41A CRPC. Mr. Goswami, learned additional public prosecutor, has also submitted that their further interrogation shall be necessary. Full stop. Considering the above, it is provided that the petitioner shall appear before the IO within a period of 10 days from today, and get their statement recorded and submit documents, if any, in support of their contention. Full stop. In the event of their arrest, accordingly, it is provided in the event of their arrest. Appear within 10 days, get your statement
on
recorded.
18
18th.
12.
Then we'll see on 18th what is, and case diary be returned back and be
Okay.
produced on the next date. Produce on-
Time out.
Yes. What is this? AB.
It is AB, my lord.
Maybe in terms of already granted, that is the petitioner, he has entered the section for purchase plot of land from the informant at the cost of 10 lakh. That 9 lakh is paid in advance. And thereafter the informant, instead of setting up land to the petitioner, has entered into after agreement with the told them to the cost of copying that. Then tell their son, if he has taken, he has issued a check in my. But if he just told him no deposit it, there is no sufficient balance in the bank. And thereafter, he has advised him to take the check of 9 lakh directly from the developer, who has participated in the copying that. Actually, he took it and message over my. Thereafter, the earlier check which the petitioner has issued, the petitioner has asked him to take it back. But instead of taking back, he has filed an FIR against him that he has cheated and
He has appeared, my lord. Again, name is granted, my lord. Other things are there, my lord. That check, my lord, he has admitted that he has deposited, and he deposited that check because, as per the petitioner's version, that he owes 9 lakh to him because it was paid as an advance for purchasing that plot, my lord, which the informant has told.
So
to
you
some
say
other-
that no custodial intervention is necessary.
My lord, I have.
but the interim
Hope-
interim
Cooperated, interim is there, material, according to this.
Here, my lord, search sheet has been filed.
Search sheet filed.
Yes, ma'am.
Interim is there.
PS number 181 of 23, dated 10/10. My lord,
Filing an objection.
What objection?
so the-
The search sheet has been filed, he is on interim, we are making it till he appears and file an objection, that's all.
Item number 33, my lord.
Hmm.
By order dated, my lord, 27/10, and order section 409 and 465 added.
Hmm.
So, my lord, this matter needs to be listed before appropriate.
Okay, it is
Because now
submitted
official
by
is
the
here, my lord.
learned additional public prosecutor that section
409 and 465.
465 has already been added
409 and
Added.
465.
with due permission from the concerned magistrate, isn't it?
By order dated
The
27/10,
concerned magistrate pursuant to an order dated
27/10/23.
20 by a magistrate na lage, pursuant to an order dated
27/10/23.
23 by the learned,
My lord,
it will be
Judicial Magistrate First Class Dibrugarh.
judicial magistrate first class Dibrugarh. In that view of the matter, list this matter before appropriate bench.
Your lordship, only prayer since CD is also available. Your lordship can kindly see the last.
No, now I don't have any jurisdiction. Moment he makes his submission, I don't have that.
And your lordship,
Accordingly, the appropriate bench on tomorrow it will not be
Tomorrow-
possible, Tuesday,
your lordship can Wednesday or
Wednesday, 29.
okay.
Yes, Mr. Buddha.
Today is the law.
Lordship 438 application.
Hmm.
Lordship, with regard to NDPS allegations,
Hmm.
FIR, my lord, which filed at page number 15, that in Silchar, my lord, in the Kasar district,
Hmm.
a vehicle was apprehended and 2 persons were along with apprehended. In that vehicle, my lord, some contraband substances were found.
Hmm.
Accordingly, my lord, case has been registered.
Who are you? Why are you apprehending?
My lord, in paragraph 6, I made an advertisement, my lord. I'm a
Hmm.
resident in the Kasar district,
Hmm.
and my lord, police have visited my house. Though no warrant or no document has been provided,
Hmm.
just on a sheet of paper, my lord, this case number was given to me.
Hmm.
That with connection to this case, we have visited your.
Yes, what is his relation?
Lordship,
Why you want him? Tell us that.
Lordship, there is one bail objection, Lordship.
Hmm.
As per the bail objection, Lordship,
Hmm.
during investigation, the accused person were interrogated and recorded their statement under section 161 CRPC and forwarded them to the Honorable Court. So the accused person in their statement stated that they have brought the suspected NDPS from Rangrikhari area under Rangrikhari PS Silchar from the possession of one Sri Tarimul Islam Majumdar, Lordship. This petitioner,
NDPS.
alias Shaumen Majumdar.
NDPS, anticipatory. And that
Lordship.
you have been named co-accused. Don't say that on the basis of co-accused, I cannot be convicted. but it's a bail and NDPS.
Also, Lordship, during investigation, it is also found that the accused Kamarul Majumdar has acquired numerous illegal properties through illegal drug business. And Lordship, this is important, during investigation, it has been found that the suspected psychotropic substance, liquid cough syrup photos were sent by Samaril Islam Majumdar from his mobile phone to the arrested accused person, Pranjit Bhattacharya.
Yes, Vaidya.
My lord, Pranjit Bhattacharya,
You
my
need
lord,
to be investigated. That is simple from the IO's report. Now this is an NDPS Act. Or if it would have been a simple case, would have been a dependent.
My lord,
They
we
need
will
to link you how you are there. So if necessary, they may require your custodial detention.
My lord, if I may appear, my lord, one of it, then subsequent to that, my lord.
Also in the
Only
statement of the
co-accused
accused
statement, my
Lordship.
Only co-accused statement, we understand, but this is a case. That's why I said it's a co-accused
my lord,
statement,
yes, my
but
lord,
it is an
definitely it is a
it
relocated,
is an this NDPS, its stringent condition, the material recovered, everything, the stage of investigation, everything will have to hence rejected. Considering the material available on record and from the material, it is seen that the custodial interrogation of the petitioner cannot be ruled out. Necessity of custodial interrogation of the petitioner will not say it is necessary, cannot be ruled out. In as much as it is the specific allegation that the petitioner is having direct link with the two persons already arrested. Two persons arrested. Public. This is
City not received Lordship.
he not received.
On requisition, the IO is on LO duty. Lordship.
Okay. Case the recall for is not received. List accordingly. When
From Gwalpara, Lordship. On 29th.
29.
Maybe.
Yes.
In fact, this matter was fixed on 28, my lord. But before that, his brother died. Yesterday was mentioned, my lord, the city was there. So it is complete.
Right.
Yes.
Item, sir.
Right.
No, not because the father died. That's why it was mentioned yesterday. Before, my lord. Here is a case, my lord. He is a journalist, my lord. Only his fault is that he has published the
Why
news.
police are behind all these journalists and most of the cases are blackmail? I do not know what is
There
this.
are, there maybe, my lord.
What is this case?
Maybe, but
This is also blackmail.
no, that is allegation, my lord.
Okay.
Allegation.
No, allegation is blackmail
Allegation
here
not
also.
about journalist.
See, I with no allegation is blackmail.
No, yes, not as a journalist. It's simple without mentioning.
No, be that as it may, but
yeah.
without
Allegation
looking
said
at the
that might
officer,
have-
I said that most of the journalists cases against them and all are allegation of blackmail.
But all.
No, I'm not saying we cannot equalize all
may not
people
stand on
in the same
footing,
footing.
my lord.
We cannot do that.
Yes, yes, my
But this is maybe a coincidence
yes,
that
my lord.
all the cases against journalists are
Some of them are already arrested.
blackmailing.
A few days back, some of the arrested also.
Some we have rejected also.
Yes, sir. That matter, that is there, my lord. I'm not disputing that perfect, my lord. Here is a case, my lord. Huh? No. Yes, sir. But the informant husband was implicated in a case, my lord.
I have a
This
prayer,
is
Lordship.
AB.
Just my lord, receive the city, my lord.
Okay, go through it.
Yes,
We'll take up.
because not fixed to this thing. Just my I can.
You go through it because we have some other method we have fixed also.
Yes,
Subject.
just after some time.
Yes. Yes,
May I
Bhuya.
please, Your Lordship?
City not
This-
received Lordship.
Lordship, I filed a complaint case against the informant and husband along with other persons. Allegations, paragraph Lordship, page 10, Lordship. Allegation made I have collected huge amount of money from the local, but no Elzahar or the complaint filed against the me, Lordship, other local people of After filing of the present case, Lordship, I filed complaint on 25/7/2020, that is page 18. And present FIR file 17 there. 107 case
Where
file.
where is your complaint?
Lordship, page 18.
Page 18.
Lordship,
You are Topojul.
I am Topojul.
Where is the informant's name?
Informant husband name is number 2 Riajuddin, and number 5 is the informant Umme Kulsum.
Okay.
That was filed on 25/7.
What is your allegation?
Allegation that they demanded money, Lordship, to miscreants, Lordship, and threatened to kill me if I do not pay their loss. I will lose the case against put me to jail.
When have you filed this petition?
That was filed on Lordship file 25/7/2023, page 20, Lordship, bottom 5, and particular is page 21, 20.
We want the date.
Date, Lordship, 25/7/2023, page 20, Lordship,
No,
bottom.
no, you have signed it on 25/7/2023. When it was filed?
Filed, Lordship,
Where is the date?
on that date, Lordship, filed there, and magistrate
No, we
forwarded.
do not know. We do not know. And when the affair was lost?
FIR was lodged, Lordship, 17/10/2023.
We have serious doubt on your petition complaint.
Lordship, in the meantime, I will collect, Lordship, the report of that report.
Because there is, you have filed before whom?
Before the magistrate, Lordship, additional deputy commissioner court, Lordship, that was.
What is the additional deputy commissioner will do?
Lordship,
And where is the,
magistrate-
there is no signature in the,
left side, Lordship.
we may
21.
further give an investigation against you on the basis of this. Yes,
Lordship,
obtain instruction from the deputy commissioner.
page 21, left
We
side,
have seen
Lordship.
page 21.
Yes, the left side.
Where is the date or date of the below the seal?
There is a seal, Lordship.
Seal is there. We have seen that. How can additional magistrate send it to Lahorighat PS to inquiry and report? Under what authority?
107 case.
Huh?
107.
107. Your case is that they have demanded money. Anyway, you have the case there. When?
The allegation only against
When?
Lordship.
The allegation against you is
Only-
believable. The
One-
allegation against you is believable. But in this part, we have serious doubt.
Only it's about one, Lordship.
You have keep in mind, right to the
29 law.
29.
20.
Other may be
Write to
protected.
the IO that what is this complaint, because that has also been sent to purportedly sent to the Lahorighat IO. You produce what happened there.
Lordship.
Yes, next.
Others may be protected, Lordship. Wife and children, Lordship. Allegation only one against Lordship. No
Not
allegation.
now, not now, not now.
29, Lordship.
Yeah.
Obliged.
Yes, what is this?
Maybe
Huh?
modification, my lord. On last of the
What modification? I'm not getting it. Tell us.
my lord, in this case, my lord, the petitioner convicted for 6 months by the trial court.
Huh.
And it was appealed in the session court.
Huh.
Session court set aside and remanded back for his trial on the ground that P13 question was not put properly.
Huh.
And I come before this court,
So you want the stay of the trial court's order?
both
Both
on-
will do.
on last
Corrected.
occasion.
There is an order from the magistrate. So stay so far relating to stay of the sentence. Not the judgment. Stay of the sentence passed by
Passed by assistant session judge
in
in session case number 101 2019.
2019.
And my lord, judgment and order dated 38/2023.
We can dispose it of this matter. Give the one anyway.
And judgment and order dated 38/2023. Passed by the
No judgment in order. We cannot stay the judgment. We can say the sentence.
and by this judgment, my lord, sentence was set aside and
Oh,
remanded.
understand. Understand. What is the purpose of this application? You do not want to go inside jail.
Sir.
Is not it? So we'll stay that. I'll pass this note. I dispose of. We'll see that. Why should we cost? First of all, if you file a false case against a person, and you on your own make a statement that I have filed a false case. So think of that. Was that person arrested?
No. So final report from both the cases, I think.
Yes, final report filed. So magistrate has lightly people like you should be proceeded this
But
way.
magistrate-
Then only false affairs will go.
Magistrate is to do, he is to follow the 40 of their principle. There must be a complaint in writing. What he did, madam, whatever was stated to be complaint. And
That can be.
cannot- No, madam. Specifically, it is there, madam. There must be a complaint in writing, madam. Your Lord. 340, your Lord,
So us.
here, your Lord. And 195. Both sections may be taken for that. 340 first part of the
Set-
inquiry was
set.
made on the 340, your Lord. 340.
Yep.
Yeah.
57. Yes.
When upon an application made to it in this behalf or otherwise, any court is of opinion that it is expedient in the,
340.
hello?
340.
340.
340.
This inquiry is made on 340, madam. That it is expedient in the interest of justice that an
Please
inquiry,
read.
when upon an application made to it in this behalf or otherwise, I come under otherwise, madam. Any court is of the opinion that it is expedient in the interest of justice that an inquiry should be made into any offense referred to in clause B of subsection 1 of 195, which appears to have been committed in or in relation to a proceeding in that court, or as the case may be in respect of a document for this so and so.
This has been registered under what section?
Then make a
No, offense is to be proceeded.
211
211, madam.
in order to cause injury to that person. 211. Now, 195 your loss. Here says inquiry if any other things is
195.
now here madam your can say 340 again madam. Record a finding to that effect. Then B is make a complaint thereof in writing. Your loss can
That we have
now
already
kindly come
passed
to
the judgment.
195. 195. 195. Sub clause 2. No court shall take cognizance, your loss. No, your loss got 195. No court shall take cognizance. Let us come to B, my of any offense punishable under any of the following sections of Indian Penal Code, namely 193 to 196, 199, 2000, 2005 to 2011. I fall under 2011. When such offenses are alleged to have been committed, then your lawsuit will come except after Roman 3, except on the complaint in writing of that court, or of that court, or by such officer of the court as the case may be, authorized in writing in this behalf, or some other court to which the court is subordinate. I am only on that matter. If yes, I have committed some offense matter. A complaint must be in writing, my lord. That cognizance to be taken on that. What the Lord and Magistrate did, my lord, he says that this order is treated to be complaint.
211 also comes under this, no?
Yes, 211 main, originally under 211. Now IPC your lord. IPC 211 IPC.
No, where is the order? IPU order?
Yeah. You know that you'll also find page 19, page 1.
200?
No, 211 your IPC.
No. I want to see the order.
Order, page 19, 1 now.
Page 20 on page 20.
Yeah. First order your knowledge is page 18.
Yes, where is the 211?
Yeah.
Yes.
My lord, what my learned friend is submitting 195, my lord. It is my prosecution for contempt of lawful authority of public servant.
Understand?
My public servant.
Ah.
For offences against public justice and for offences relating to
Suppose you
documents.
file even false affidavit filing and all these other provisions are
But
there.
this is the my lord immunity granted to my public servant, my lord, if it is my, because the law is 195.
195.
My lord.
Yeah,
And that's now my learned senior friend.
Yeah.
Prosecution for contempt of lawful authority of public servant.
Where is my book? Yeah, that's one. I have marked this. Yes.
Authority. 195 manner prosecution for contempt of lawful authority of public servant for offences against public justice and for offences relating to.
Now, therefore, I say just say so as 211.
Yes.
Yeah, IPC your lord.
That is
IPC.
211 is yes.
False charge of offense made with intent to injure. Whoever with intent to cause.
Whatsoever, 211 is inclusive.
Inclusive.
Now, this is 195.
Nothing.
No court shall take cognizance. Okay.
Yes.
A, B, under section of following section of Swencho, both. Okay, except
On the complaint.
on the complaint. Now, subsequent to this is the power of a court.
Right.
Suppose somebody files an false affidavit, he abused the process. These are the, if it covers, this court will have to lodge an FIR. Now, there is an incorporation 195A.
Yes.
Earlier, it was only by the courts. Now, 195A is given for the purpose of other section, which 195A of IPC. Is not it? So that also comes under section 195. So therefore, I think he's correct. What you want to say? We have passed the judgment and reported in JLT. Now I forgot everything. Now after reading this, I can recall everything.
In this case, my lord, the protection that is my learned senior friend is 195, my lord, regarding any application has to be made by the my lord. That may not come, my lord, because this is the immunity given to the public servant.
No. This is not immunity given. Kindly read.
Prosecution for contempt of.
No court shall take cognizance. No, prosecution for contempt of lawful at public servants, for offense against public justice.
Yes.
That it will come against public justice.
Yes.
Or offenses relating to documents given in evidence. That's why I'm saying, suppose somebody files an false affidavit. Here, it comes to the notice of this court. This court cannot directly file. We'll have to say an officer of the court to lodge a complaint under section and procedure under section 197 is to be followed. This is what says. So if 2011 is included under section 195, then included. We cannot change it. And cognizance is taken under 211. Yes, এবার জেল
Hey, 211, my lord, kindly see, my lord. Whoever with intent to cause injury to any person institutes or causes to be instituted any criminal proceeding against that person or falsely charges any person with having committed an offense, knowing that there is no just or lawful ground for such proceeding or charge against him, shall be punished with imprisonment.
whatsoever, cognizance is taken under 211.
11, my.
And to take cognizance under 211, a complaint is required.
My lord, 304.
Just you can go through it. We'll
my
take
lord,
up this matter
304,
next
my
week.
lord, 304, my lord, says, my lord, complain or otherwise. 30
Complaint or otherwise?
Otherwise, my.
Otherwise means what? That I have seen. Otherwise means what?
Because or, my.
Complaint by whom? Complaint by whom? When it's a complaint, what is the definition of complaint? In CRPC, two, I think, have or something like that.
Yeah.
Not before a police officer, but before a magistrate. Is that it?
No. Yes, my.
If I can recall it.
Yeah.
It's most of it.
Complaint means any allegation made orally or in writing to a magistrate with a view to his taking action under this law. He might. And that's
Just give me a minute.
Look.
Just I'll recall.
Look.
Just give me 2 minutes. What is the offense of malicious prosecution?
That has to be, my lord. It is as per 211, my lord. Also offense punishable with death. It depends upon the, my lord, where, my lord, the evidence has been laid. Also, the offense that is been.
What is an offense?
Charged.
Offense on to 2023 6 ZLR 302.
Who?
2023 6 ZLR 302.
He's good. Who never like malicious
211.
malicious prosecution.
So malicious prosecution, there must be a complaint.
So 211
Happy.
but this is what what is the text of this text?
Where is let us see section 340, no? 340.
340.
Yeah, this
CRPC.
Yeah.
To go through this judgment, this
No.
is my limited understanding.
No.
And in terms of this judgment, this request, this petition is liable to be allowed.
Let it,
You
some
go through it.
other day.
You go through it.
Plus.
My understanding may not be correct also. That's why you go through it. What you have argued, that is
unless it
what
is-
what has been reflected, but now everything
let us
is
go with
2023.
it.
My lord,
6 ZLR 302.
let's have note.
Huh?
Have note. 2026 year. That's it.
When? I
Next
think
week,
he is the case.
next week, or my lord, any convenient date.
Any urgency?
Otherwise, stay is there, matter. Next Tuesday, matter. Let it be finished, matter. Because there's already a lawsuit. Already there, matter.
Okay, as agreed to with the learned counsel for the parties, please this matter on.
When is the
Next
contract?
Tuesday. Wednesday.
Sir,
Tuesday.
when is it?
Huh?
Are you
5th of December. Huh? Mosmi.
Is
Yes, sir. এখানে এক করলো
Candidate's mother is expired.
Huh?
Indian candidate's mother is expired.
Whose mother expired?
Candidate.
Now tell us what is this case?
It's not up to date. Okay, example.
There is a DV, an award was granted, some amount compromised. Then there are some other application. Then it was appeal was preferred. Now all proceedings are stayed. Who made a mention? This is a listed by mention.
Not by
Yes.
the candidate.
Huh?
Not by.
I
Who-
made it. Because it
We
is
do not
pending since
appreciate.
2019.
Please in brief and about that.
When?
So Monday is the start after a week.
Give a date. Next week, give a date. First of December. Interim order shall continue till. Yes, Mr. Bush, what is this?
My lord, question
What is your grievance?
my lord,
What is the ground of causing?
but the ground of question is this, my lord, negotiable instrument act.
Hmm.
My lord, kindly see there are two opposite.
Hmm.
Now opposite party number from opposite party number 2,
Hmm.
I took a loan of rupees 1 crore 15 lakh.
Hmm.
And as the I'm a government contract, as I could not pay the amount,
Hmm.
he filed an FIR.
Hmm.
Giving name
Hmm.
that he took loan from those persons
Hmm.
and I'm not repaying the amount.
Hmm.
That's why the case
Be
I may be
registered.
punished
Yes.
according to the law.
Yes.
My lord, I don't know opposite party number.
Hmm.
He handed over the check to the opposite party number. I don't have any
So,
legally.
according to you,
My-
where is the complaint? Show us the complaint.
My lord, before that, my lord, kindly come to the FIR.
FIR at page
Page 22.
22.
May I read, my lord?
Now, okay, then
Now, my lord, kindly consider this FIR is a public record.
forget about this
My lord.
FIR.
My lord. Then my lord, he filed a complaint case
Hmm.
against me, which is at page 30. Para 1. May I read, my lord?
Who issued this notice, page 24? Abdul Kader.
My lord.
On behalf of Mofizul Haq. Okay?
Yeah.
Where is the complaint?
Complaint is at page 30. Sir. Next, sir.
Okay, complaint. At page 30.
30. Annexure 5.
Yes.
My lord. To accept section 138, there must be legally enforceable date. Against. I don't have any date against the.
Who will decide that not legally enforceable rape is there or not?
My lord, as per the FIR, my lord, it is all crystal clear, my lord. The
In the FIR, it has been written that, see, I am X. This person has taken low money from many people, including me. I am having a problem, so register an FIR. This is not the complaint in this case.
My lord, kindly peruse the FIR one thing.
I have perused that.
My lord, kindly.
From a group of people.
No. He filed the FIR. Kindly peruse.
Yes, read it.
That, sir.
Yes.
With the following person, named person, who was a contractor, and he taken many amount at various times from me, with a promise of giving share of the construction work. And I have also taken amount from the following person. Who has taken the amount? Number 1 and 2. Name of the person, contractor, number 1 and 2. Am I clear?
Yes, I am clear. According to you, as per the Mir Ali, according to Mir Ali, not only Mir, you have taken money from Mir Ali, and Mir Ali has taken money from those person. We agree to this.
My lord.
We agree.
My
No problem on that.
Yes.
That you have taken, the Mir Ali taken money from the respondent here. And he says that I have not been able to return to this money. So lodge an affair. This is his case, Mir Ali's case.
Mir Ali.
Now a negotiable instruments case is to be proceeded, or complaint is to be proceeded on the basis of statement made in the complaint and whether notice has been issued. And the procedure required under those things are there. Now there is a notice issued. If I am wrong, just correct me. A notice is issued under section 138 saying that this is the sake, you are a contractor. He is a contractor. He has taken loan from me for construction of this nursing college, but he has not returned the money. Instead, he paid this, issued me this check. I deposited it. This was bounced. He promised me I will give you. Thereafter, I issued a notice. After receiving the notice, he replied that I do not know you. There is no due liable. Then the person replied to you. Okay, fine. When payment is not paid within the stipulated period, a complaint case is filed. A section initial deposition is taken. On note, similar statement that there is a due. In this construction, he has taken money from me. This check is issued. On the basis of cognizance has been taken. Now, enlighten us to quash a complaint under 482. Can we go to the FIR of the X, ignoring all these facts and determine that no, he is wrong. We will have to rely on the FIR. That is, you prove it. Initial burden is upon him to discharge. Suppose initial burden presumption is against him, against you, that
Against me.
against you, that there is no enforceability. The moment that is rebutted, he will have to prove it that there is a due.
Very true. But here, my lord, kindly consider what the law is that I don't have to depose in the court because I have placed
You have placed an FIR,
I have placed a document which is a public record.
which is a
Which is a public record, FIR one.
okay.
Court record. My lord, kindly
We say that we accept that the statement made in FIR are correct.
My lord,
How that will relieve you from the
okay.
demand?
My lord, that is
This may be in addition to that.
My
How do you know?
my lord, that is the law. My lord, I am quoting that. Kindly consider one thing.
Hmm.
The complainant has to prove his case
Where?
beyond unreasonable doubt.
Where?
Kindly,
Where?
kindly,
Yes.
madam.
Yes.
He has to prove his case beyond reasonable doubt.
Hmm.
And my burden is preponderance of probability. I don't have to prove the case beyond reasonable doubt. Now, this is the law, madam. And I am
That's
coming.
what we have shown, that you will have to discharge only initial burden. That yes, there is no due.
Yes, my lord.
Then it is onus upon if you can satisfy that.
My lord.
Satisfy that before the court.
My lord, I will satisfy your lordship. My lord, I am trying my best, my lord, with my limited knowledge. My lord.
Yes.
There are 30.
Hmm.
There are 3.
Hmm.
The proviso appended to the said section provides for compliance with legal requirements before a complaint petition can be acted upon by a court. Section 139 of the Act merely raises a presumption in regard to the second aspect of the matter. Existence of legally recoverable debt is not a matter of presumption under Section 139 of the Act. It merely raises a presumption in favor of the holder of the check that the same has been issued for discharge of any debt or other liability. The court below, as noticed herein before, proceed on the basis of Section 139 raises a presumption in regard to the existence of a debt also. The court below, in our opinion, committed a serious error in proceeding on the basis that for proving the defense, the accused is required to step into the witness box, and unless he does so, he would not be discharging his burden. Such an approach on the part of the court, we feel, is not correct.
Mm.
My lord, I can discharge the burden by placing documents on record.
Mm.
An accused for discharging the burden of proof placed upon him under a statute need not examine himself. He may discharge his burden on the basis of materials already brought on record. An accused has a constitutional right to maintain silence. Standard of proof on the part of an accused and that of the prosecution in a criminal case is different. My lord, next, para 33, that earlier judgment was considered. Here, my lord, at G, first right hand column, at G, my lord, the burden upon the defendant of proving the non-existence of the consideration can be either direct or by bringing on record the preponderance of probability.
Mm.
Now, kindly come to page 63, next page, man.
Mm.
Benefit of presumption arising under section 118A in his favor. The court may not insist upon the defendant to disprove the existence of consideration by leading
Which paragraph?
The same paragraph at page 63 from top, my lord, towards right hand corner. The court may not insist upon the defendant to disprove the existence of consideration by leading direct evidence, as the existence of negative evidence is either possible
neither possible, not
neither possible, not contemplated, and even if late is to be seen with a doubt. Furthermore, whereas presumption must prove the guilt of an accused beyond all reasonable doubt, the standard of proof so as to prove a defense on the part of the accused is preponderance of probability. Inference of preponderance of probabilities can be drawn not only from the materials brought on record by the parties, but also reference to the circumstances upon which he relies. 35. A statutory presumption has an evidentiary value. The question as to whether the presumption, whether to revert it or not, must therefore be determined keeping in view the other evidence on record. For the state purpose, stepping into the witness box by the appellant is not imperative. In a case of this nature, where the chances of false implication cannot be ruled out, the background facts and the conduct of the parties together with their legal requirements are required to be taken into consideration. My lord, kindly come to 10, paragraph 44 at page 65. Paragraph 44 read the presumption of innocence is a human right. In certain such judgment, Article 6.2 of the European Convention on Human Rights provides everyone charged with a criminal offense shall be presumed innocent until proved guilty according to the law. Although India is not bound by the aforementioned convention and as such, it may not be necessary like the countries from forming European countries to bring common law into land with the convention, a balancing of the accused rights and the interest of the society is required to be taken into consideration. In India, however, subject to the statutory entirety, the state principle forms the basis of criminal jurisprudence. For the aforementioned purpose, the nature of offense, seriousness, as also gravity thereof, may be taken into consideration. The court must be on the ground to see that merely on the application of presumption as contemplated under Section 139 of the Negotiable Instrument Act, the same may not lead to injustice or mistaken conviction. It is for the aforementioned reason that we have taken into consideration the decision operating in the field where the difficulty of proving a negative has been emphasized. Proving a negative is much harder. It is suggested that a negative can never be proved, but there are cases where such difficulties are faced by the accused, that is honest and reasonable mistakes of fact. In a case recently, now currently come to paragraph 45. We are not obvious of the fact that the state provision has been inserted to regulate the growing business, trade, commerce, and industrial activities of the country, and the strict liability to promote greater vigilance in the financial matters and to safeguard the faith of the creditor in the drawer of the state, which is essential to the economic life of a developing country like India. This, however, shall not mean that the court shall put a blind eye on the ground reality. Statute mandates raising of presumption, but it stops at that. It does not say how presumption drawn should be held to have reversed. Other important principle of legal jurisprudence, namely presumption of innocence as human right and the doctrine of reverse burden introduced by Section 139, should be deliberately balanced. Such balancing act indisputably would largely depend upon the factual metric of each case, the materials brought on record, and having regard to legal principles governing the case. Now, my lord, admittedly, I took the money of the party number. If I have any legally interpreted that against opposite party number, he cannot hand it over the check from other party to file case against. This is my. And there is one more thing one more citation I want, please. Here, my lord, I want to rely on page, paragraph 33, 35 and 30. Here, my lord, the Supreme Court discussed about doctrine of abuse of process. My lord, para 33. The doctrine of abuse of process of court and the remedy of refusal to allow the trial to proceed is well established and recognized doctrine both by the English court and the court in India. There are some established principles of law which part the trial when there appears to be abuse of process. 30. Lord Mary in so observed that there can be no doubt that a court which is endowed with a particular jurisdiction has power which are necessary to enable it to act effectively within such jurisdiction. A court must enjoy such power in order to enforce its rules of practice and to suppress any abuse of the process and to defeat any attempt hurting of its process. The power which is inherent in a court of jurisdiction.
Which paragraph? 35.
34. May I read again, ma'am?
No.
The power which is inherent in a court jurisdiction to prevent abuses of its process and to control its own procedure must in a criminal court include a power to safeguard an accused person from oppression or prison. In his separate pronouncement, Lord Kelvin, in the same case, observed that while particular criminal proceedings constitute an abuse of process, the court is empowered to refuse to allow the indictment to proceed to trial. In 35, in so case, the Privy Council defined the word abuse of process as something so unfair and wrong with the prosecution that the court should not allow a prosecutor to proceed with that, with what is in all other respects a perfectly supportable. 30. In the leading case of so on the application of abuse of process, the court confirms that an abuse of process justifying the stay of prosecution could arise in the following circumstances, where it would be impossible to give the accused a fair trial, or where it would amount to misuse, manipulation of process because it offends the court's sense of justice and propriety to be asked to try the accused in the circumstances of the matter. So, basically, and our High Court said that there must be legally enforceable, and it is crystal clear from the court. I don't have legally enforceable date against the officer.
Heard Mr. G. Bulsha, Learned Counsel for the petitioner. Also heard Mr. I.A. Talukdar, Learned Counsel for the respondent, M.S. Goswami. Goswami is there? Not there? Huh?
No, madam, not there.
Okay.
It's a complaint case.
The present application under section 482 read with section 397 and 401 of the Code of Criminal Procedure 1973 has been filed assailing the order of cognizance dated 17/1/2022 passed by the learned magistrate, learned additional chief judicial magistrate Kokrajas, whereby cognizance against the petitioner under section 138 of the Negotiable Instrument Act 1881 was taken in complaint case NI number 03 of 2022. Full stop. The basic grievance of the petitioner is that there is no enforceable due against the present petitioner as alleged in the complaint. Full stop. Complaint. Inasmuch as through filing an affair before the IGP Kokrajhar district dated 22/9/2020 by one Miar Ali alleged that said Miar Ali has taken taken money from many persons, including the petitioner, and in turn given it to the said opposite party, including the opposite. You are the petitioner. Opposite party. Opposite party number one. And the cheque which is alleged to have been dishonored was in fact issued as a security cheque to the said Miar Ali, and the Miar Ali has in turn handed over the said cheque to the opposite party, and opposite party, without having any financial relation with the petitioner or due, has presented the said cheque before the bank, and such cheque got dishonored. Therefore, in view of such factum and lodging of FIR, which is a public document, the learned court ought not to have proceeded with the matter and could not have taken cognizance under section 138 Negotiable Instrument Act. While arguing,
My written objection is there.
we are allowing this.
Yes,
We are allowing his
No,
petition.
not allowed.
Then why your written argument is required? Dictating the order? Mr. Boishya further submits that the proviso to section 138 section 139 of the NI Act merely raises a presumption of existence of legally enforceable debt. Merely raises a presumption in favor of a holder of the cheques. And therefore, the court, the learned magistrate below, has committed a serious error in proceeding on the basis that the accused is to appear before the court and produce his defense. Mr. Boishya further considers that such course of action has been debarred by the Honorable Apex Court in the case of Krishna Janardhan Bhatt versus Dattatreya G. Hegre, reported in 2008 4 SCC, page 54. He further, while relying on the aforesaid judgment, he contends that presumption of innocence is a human right, and therefore the learned magistrate, ignoring such factum of existence of FIR, could not have taken cognizance only on the ground that there is a presumption against the holder of a sect. Full stop. While submitting that therefore, Mr. Boisha submits that the entire process is nothing but an abuse of the process of the court, and therefore this court can very well set aside and quash the entire proceeding in exercise of its power under section 482 CRPC, inasmuch as in the case of Bhajanlal versus so in no unambiguous term, the Honorable Apex Court has held that when there is abuse of the process of this court can interfere with the High Court can interfere with a criminal proceeding to avoid such abuse of the process of the full stop. Per contra, Mr. Talukdar, learned counsel for the petitioner, submits that a magistrate is to take cognizance on the basis of the material and statement made in the complaint, as well as his initial deposition recorded under section 200 CRPC.
Yes.
Section 200 CRPC. On the perusal of aforesaid, the learned magistrate has taken cognizance. Therefore, a bare reading of the complaint reflects that a case, prima facie case under Negotiable Instrument Act 1922 is made out. I have given anxious considerations to the arguments advanced by the learned counsel for the parties. The whole plank of argument of Mr. Boisha is the existence of an FIR. From the perusal of the FIR, it is seen that one Muhammad Mir Ali, M-I-E-R, one Muhammad Mir Ali lodged an FIR before the IGP Kokrajhar district on 28th of September 2020 against the petitioner and one Janak Kumar Narjari. Who is Janak Kumar?
The son of the
Petitioner and his son.
my lord, only he is appearing for both the opposite party.
Who are the both the opposite parties?
Opposite party number 1 is the mayor. Opposite party number 2 is the mayor.
Okay. Come on. ঠিক আছে কি করলো করেছিল against the petitioner and his son that the petitioners and his son were the contractor and had taken money from the informant with promise of giving share of construction work, and the said Mir Ali within bracket informant has taken money from the persons listed in the aforesaid affair. The grievance raised in the affair by Mir Ali is that the petitioner and his son are not repaying said borrowed amount to the informant, and he is facing problem in repaying the due which he has in turn lended from other parties. Where is the name of this person? There are total 8 names.
My lord, there are one more case wherein the name appeared there. Here, my lord, kindly say
What about, tell us, what about this man?
this man, my lord, his name is not here, my lord, but kindly see number 2, Mr. So and others. Number 3, Mr. So and others. All names were not given.
Okay. Okay. Full stop. Since the full stop. Since such affair is the core of contention, the same is quoted here in below, page 22. Okay. Thereafter, it is to be noted that in the aforesaid list of persons, the name of the present respondent number 1 is not reflected. From the material available on record, it is also seen that on 11/12/2021, a notice under section 138 within bracket B of the negotiable was issued on the pretext, on the alleging that the petitioner was a contractor in constructing a nursing training building at Kokrajhar. And during such construction work, when the petitioner faced financial problem to complete the nursing training building and as well as other construction work, requested the respondent number 1 for an amount of rupees 24 lakhs as loan, which was paid by the informant. The basic contention lodged in the aforesaid demand notice is quoted here in below. Paragraph 1, paragraph 2, paragraph 1 and paragraph 3. Okay. Page 34. Okay. The petitioner, through his counsel, replied to such notice on 21/12/2020 with a contention that denying taking of loan, and further taking a stand that the informant in the FIR, as discussed here in above within bracket supra, namely Muhammad Mir Ali, handed over 2 numbers of sex mentioned above, the 2 numbers of sex to the respondent number 1 belonging to the petitioner, and for wrongful gain, the respondent number 1 had misused the said 2 numbers of sex and deposited at the bank for encashment. Full stop. Where is your reply? Here you made a statement that he has made a reply. Okay, pursuant to this, as reflected in the complaint case, pursuant to this, the case under section 138 negotiable, the complaint under Section 138 Negotiable Act was filed before the learned magistrate. The basic contention in the said complaint is raised in the said complaint case is quoted herein below. 1 paragraph 2. Then paragraph 4. Page 30, 31, 32. Okay. Thereafter, the negotiable complaint was registered. Complaint was registered, and statement of the complainant were taken and taken on the perusal of the same. After appreciation of the same, the learned magistrate by the impugn order dated 17/1/2023 took cognizance under negotiable instrument. Full stop. From the perusal of the aforesaid complaint petition as well as the demand notice, it is seen that the respondent number 1 has specifically stated that there is an legally enforceable debt and for which the checks were issued and which were dishonored. It is also stated in the complaint that notice were issued and same has duly been received by the petition. Similar is the petition. That being the position, on reading of the complaint, taking the same as a whole reflects that a prima facie case under Section 138 of the negotiable instrument case is made up. Therefore, this court is have to look into whether on the basis of the FIR dated so and so, this court in exercise of power under Section 482 or in exercise of its revisional power can entertain into the determination of a fact that the FIR relates to the same matter and this was a security check and there is no legally enforceable debt only on the basis of the aforesaid FIR. Full stop. It is there is no quarrel on the proposition of law that when admitted materials are available which shows that the lodging of a criminal case is an abuse of the process of a court, this court is not powerless to interfere with such criminal proceeding inasmuch as to avoid abuse of process of court. The reading of the FIR in the considered opinion of this court reflects that the informant in the FIR, that is Muhammad Mir Ali, is having a grievance against the present petition for the reason that the present petitioner has taken money from him and the present petitioner money from him which he is not repaying to said Mir Ali, and in turn Mir Ali could not honor his debt to the other persons from whom he has taken loan, including the present petitioner. Even if assume that that contention of the FIR is correct, this court cannot come to a conclusion on the basis of such allegation made in the FIR that there is no other enforceable liability between the petitioner and the respondent number 1. Full stop. That being the position, this court cannot set aside or quash a criminal proceeding or a complaint when a prima facie case is made out. Now, coming to the abuse of the process of this court, law is by now too well settled that that a court which is endowed with a particular jurisdiction has powers which are necessary to enable it to act effectively within such jurisdiction. Full stop. In the case in hand, there is no dispute that the additional Chief Judicial Magistrate is lacking such jurisdiction or power to exercise, to power to try an offense under section 138 of the additional jurisdiction. Try an offense under section 138 of Negotiable Instrument Act. Full stop. An abuse of process is something unfair and wrong with the prosecution that the court should not allow a prosecutor to proceed with what is in all other respect a perfectly supportable case. Therefore, certain criteria has to be determined. Certain criteria are to be looked into when it is alleged that it is an abuse of the process of the court. Firstly, where it would be impossible to give an accused a fair trial. And secondly, where it would amount to misuse, manipulation of process because it offends court's sense of justice and propriety to be asked to try the accused in circumstances of particular case. In the case in hand, as discussed herein above, the petitioner shall have a chance to a fair trial, inasmuch as it is the only initial presumption against the accused, and if an accused is able to discharge his burden, the onus will shift to the complainant to prove such case. Therefore, the petitioner will have a fair opportunity to rebut such presumption as well as to contend what have been contended in the present case. That is the factual dispute, and that it is a security sake meant to merely, not for the present petition. Therefore, in view totality of the matter, this court is of the considered opinion that the further proceeding of filing of negotiable instrument case cannot be treated as a misuse, manipulation of process. Full stop. In view of the aforesaid, this court finds no merit in this present revision petition. Accordingly, same stance dismissed.
There may not be any findings on merit.
No. While parting with this record, it is made clear that this court has not commented on that this order should not be treated as a comment on the merit of the claim of the present petitioner as well as of the respondent complainant. Full stop. Respondent complainant, and this court has determined only the exercise of power under section 482 of the CRPC.
Yes. One more thing. A date may be fixed.
Yes. As the learned counsels are duly represented, the petitioner and respondent shall appear, respondent number 1 shall appear before the learned trial court on 4th December. Which one?
16 December.
16th of December 2023. Same in the next also.
No.
Huh?
Yeah,
Only one.
only one.
Okay. You said there are some other cases.
That has not been
Okay.
obliged. Obliged.
Yes.
May I please Rakib?
Yes.
Rakib is 41, there is stay order. But so far, copies produced concern.
What is this case? Tell us. Forget about the respondents.
The quashing of the complaint
On what ground?
under section 138.
On what ground?
Question is, my lord, so far, my lord, section 138 B has not been complied.
138?
138 B, the B has not been complied. Because when prisoner within 30 days, notice, demand notice to start, but notice was served after 1 day.
That is a matter to be determined by in the trial.
It is a question of law, my lord.
Question of law. How can it say question of law on which date it has been submitted?
Question of law, my lord. So far, common case, my lord.
At time Supreme Court removed that corona, my lord. That was taken away. That notification are not having handicap, my lord.
I am not on that. Limitation not.
Absolutely, my lord. Limitation was also taken away.
120.
May I pray like this, my lord?
In this case, my lord, service has yet not completed upon that not approved.
They are repairing. Okay, Mr. B.K. Mahajan, Learned Counsel has entered appearance on behalf of the respondent number
2, my lord.
Who is one? Okay, respondent number 2. In view of the aforesaid, the matter is ready as regards service. Accordingly, list it on
any convenient.
Give a date. 19th of December.
My lord.
Both cases?
No, my lord. Second is, my lord. Absolutely, my lord. Of course, my lord, he should have come with clean hand. This is the second, my lord. With all respect, my lord. The revision application, my lord. With all respect, my lord. And the first was withdrawn. Two things, my lord. First, he has not mentioned that it is a second revision, my lord. Thereafter, my lord, the first was withdrawn without liberty.
Then this file.
In this file. And then what Apex Court has said, my lord. It cannot be because the
now you give that material that you have he has done it.
Yes.
Record
is there annexed with that first case, my lord.
My lord,
no, out of the same sake.
Same sake.
No.
Tell me, one is 819 of 20.
First one is gone, my lord. Lordship has passed an order. First one, my lord. Item 41 is gone.
Okay.
But with 41, my lord, the record was sought for which pertains to this case, my lord. For in 42, the record has come, my lord. That first case, my lord, which was withdrawn by him.
Criminal petition number 170. Criminal
41, we are adjourning that it is
gone.
It's gone. Okay, now what about the 42?
42.
42.
With 42, it is a second revision, my lord. The first record was sought for, which was withdrawn by him, my lord. That is also before your lordships.
Where is the matter?
That is item number 41.
173/23.
Item number 41.
No, it will be in the record. Dispose of matter. This is a dispose of matter. Criminal petition 173.
Yes. My lord. That was, my lord, with all respect, my lord, only
what
one.
You say?
Lordship was very initially without taking any step.
No, forget about that. Suppose you file a challenger, whether revision itself is maintainable. That is the issue.
So it is also, my lord, quashing of the complaint.
We understand. You file a quashing of the complaint by filing a revision.
Without attaining any finality. The very initial state, I withdraw. But liberty was also sought. Honorable Court says that so far the quashing of the complaint, even dismissal, you can file subsequent.
Where is it? Where is it finding?
That is a verbal.
Oh, don't say about verbal things.
So far, my lord, Honorable Supreme Court also stated that even dismissal of earlier quashment application, subsequently can. And that is
if there is a
change. The earlier, my lord, on record, the lordship the criminal petition number 173. And so far,
Under same circumstances or
Exactly.
being materially different from earlier
my
application.
lord, pleading is different and ground also found different.
Malad, মই একদম সৰু
Okay,
কৰি দিওঁ।
when are you taking?
No, this can be, Malad, with all this, it'll take a minute, Malad. Two questions to moi koi. Malad, what has happened, Malad? 2 points to be noted, Malad. One should come with clean hands. I've got nothing to say, Malad. In this application, there is no mention about the earlier application. He has not come with clean hands, apparent on face of the record.
Any statement that this is materially different?
No,
that
no,
it
no,
is
no, that I'll place, Malad. It'll take a minute, Malad.
Sense circumstances. What are the sense?
What was under
Initially, it is
What was under challenge, the same is under challenge now. Malad. I'll come to that. Malad. It'll take a minute. Malad, first of all, no mention. Secondly, Malad, the first one was withdrawn without liberty to file a subsequent application. Malad. These 2 points on record, Malad. Now, my lord, what was under challenge in the first application? I'll be very cryptic, my lord. My lord, I have that 173 record, my lord.
170, I'm with 173.
173, my lord. Can you see, my lord? The criminal petition was preferred under article, sorry, my lord, under section 482 of the Code of Criminal Procedure against the impugned complaint proceeding in the, so against the impugned complaint proceeding, my lord, the entire proceeding. Am I clear, my lord?
What is the difference between these two petitions?
Nothing. Only law points are different. Can you see, my lord? So what was Apex Court has said, what was under challenge, if in the second application, liberties has to be there. Subsequent to that, my lord, new grounds are to be there. Under
Changing
challenge.
circumstances, new material.
Absolutely. It is not there. Kindly see, my lord. What was under challenge in the first one? In the matter of gone, my lord, entire complaint. Thereafter, my lord, that the petitioner served the reply to notice, that is under challenge, my lord. More, my lord. There, my lord, 1 ground more. Here, 1 ground less, second one, my lord. Third, my lord, the learned court below proceeded the case by passing an impugn order without, my lord.
1910.
Exactly, my lord. 1910, my lord.
Without taking cognizance of offense against the petitioner and also pass an impugn order 18-1.
These 3, the Apex Court has used the under challenge, my lord. These 3 were under challenge in the first application. Am I correct, my lord?
Yes.
These 3 were under challenge. And the present one, my lord, what is under challenge? Present one, my lord. Present bears the number 329.
329.
329, my lord. The same thing, my lord. The criminal petition was preferred under 482 of the to prevent miscarriage of justice and to quash the impugned complaint. So complaint is gone, my lord. Same as the earlier one. Under challenge.
Yes.
The second and third, my lord, with all respect, my lord. Second could be. But second is also same, my lord. So the learned court below proceeded the case by passing an impugn order dated 1910. Same, my lord. Gone, my lord. So there earlier 1 ground more was taken. Not 1 ground, my lord. Another object was selected, whatever be it, my lord. So, my lord, this does not lie. This does not lie. Apex Court is clear. And the judgment is this, my lord. May I just place it before your lordship? And the paragraph would be, my lord. Paragraph 11, my lord. And this is, my lord, Vishnu Lal Bharma. Definitely, my lord, second application lies. Normally, the courtesy should be, there has to be a mention in the second application as regards the first application which was withdrawn. And normally, when the application is withdrawn, my lord, with a liberty needs to be sought for, my lord. And it has to be granted by the court, my lord. These are, my lord, the parameters. And thirdly, my lord, the whatever is under challenge, my lord, in the first application, new grounds are to be there, my lord. And that is that incorporated in para 11. This application doesn't lie, my lord, doesn't survive. Not maintainable. Para 11.
Lord, ground or what different?
No, I'm not saying ground. That is challenge. That clearly see the language of the Apex Court, my lord.
Pleading also found different.
First one, my lord. In a second petition maintainable under section 482 of the Code of Criminal Procedure on grounds that two are available for challenge. Have I made my position clear, my lord? So it has to be, my lord, at the top, my lord, in the matter of. Not grounds to my lord. Grounds put up for challenge, my lord. He challenged 3 things, the entire complaint, order dated 1910 of a particular year, my lord, and the third one. Here, my lord, only two such materials find out, my lord. Second application, my lord, very two under challenge. This doesn't survive.
Yes.
My lord, if withdrawal of earlier
If you
petition-
want some time, you can,
Okay, if
you
withdrawal-
can give some you time.
one.
If you want to proceed, we can proceed. If you want some time, we can give you some time along with that.
Yeah.
You
My-
also look into
and-
this matter.
and-
Yes, yes,
Think over it.
My lord,
My lord.
responded to not up to Trisuda over earlier withdrawal. Because they are
No, it's not a question of I being, I don't make,
No,
my
that
lord, I
is
quote law.
not the issue. That should not be your prejudice argument. Your argument is somewhere else. Your argument should be somewhere else. That you will have to argue. I cannot advise you what to argue.
another case.
My lord.
I'll file.
Let us see what
I'll
matter.
file for the-
Let him have a chance. Before
Yes,
I-
yes, my lord.
Suppose we are also in view that yes, at least he ought to have mentioned there may be two views, possible views.
My-
One is that so far relating to 2023 judgment,
My lord.
there was a case where earlier determination was made. And so far related to 482, there is no review power. Therefore, court said in the guise of filing a fresh petition, you cannot have a review. This is one aspect in a final sense. Whether he will argue or not, I do not know.
There is a-
That was not dismissed on merit,
my
my lord,
lord,
withdrawal only.
2019.
Earlier, this also.
Yes, yes.
Lordship
This
2019.
Withdrawal,
2023
withdrawal, withdrawal,
on withdrawal.
withdrawal. Gone, my lord.
Okay, we'll see that. then.
And lordship over.
No, don't argue. If you argue, you'll have to decide right
I am
now.
with the court, my lord. So far, my
Oh, don't be with the court. Be on your own.
because so far my submission citation also saying something. Because
Your submission
No,
is saying that
no,
yes, it is can
no
be
finding.
allowed. It can be allowed in a
No finding.
circumstances when new materials and substance
Or challenge, my lord.
no finality arrived.
they are same circumstances or being material different from earlier application. So these two conditions will have to fulfill.
Absolutely, absolutely.
Want to proceed today?
No.
Okay,
Ajab.
list together on the next date.
My lord.
90 on agree to 90. What is a deal likhechil, huh?
Lordship so far item number 51 interim order.
Okay, we will decide this interim order till then.
No, in 42, no interim order.
No interim. There can be any interim on 42.
42 no, but 41.
Yeah, 41.
In 41, interim order is there, 42, no interim. Highly obliged.
Malat directed who take instruction. What is the link about this petitioner? I have the CD in the Malat office. Malat.
Huh?
Yes, there is Malat, so I have pinned the CD. Malat.
Okay, series there.
CD is there, Malat.
Okay.
So Malat, yes, he is the husband of one of the Malat. Malat
Against
member.
there is an allegation. Allegation means he is a member of the committee.
Yes.
Yes.
Malat, one main person who is Malat, official person who is Malat up to the Malat photograph and all these Malat of the site.
Yeah.
PMI house Malat. So he is supposed to Malat old house, then Malat proposed site, then plinth, roof cast, then completed house. All geotagging he should be uploaded. He confessed that he has uploaded same photograph in different.
I've seen that.
Manipulating the geotag.
And there is no improvement. All the first old houses and same houses tagged in
Now-
many places.
Yes, and now several witnesses, Malad, they have stated that yes, we have house already. They have house. They have got the 3 installment, and
But they have not constructed the house.
No, only plinth. And one Malad, one is surprisingly he has Malad already RCC building. He has constructed above the roof. Malad, it is not permissible.
Not permissible.
And
This is
now-
for homeless
now-
people, huh?
Yes, Malad, here several witnesses, Malad, 4 witnesses will have stated that we have also given money to Nur Alam for making me in the beneficiary list. So
He's the agent.
wife
That's
is,
why he's here. That's why I asked that why it is.
so they have given the money to
All
him,
husbands.
So he included the name in the beneficiary list. So that is the fact. Malad. Government money is
That's why I said, why are you here?
As per FIR, my lord, there is no allegation and
No
even
allegation.
forwarding.
So there should not be any apprehension on your part.
My lord, there's
There is
someone
no
who was,
allegation in FIR. According to you, my wife is the member of the committee. She is not any apprehension. Why should you have the apprehension?
My lord, someone may be stated, my lord, but they are, my lord.
Give us the CD. And Rosie flag mark.
Yes, yes, my lord. Witnesses, important.
This is motion.
Most of
Yes, motion.
type flag, sir, my yellow.
If this is the way public money are. Okay, we'll pass this.
Photograph also there, my lord.
We'll see this. All likelihood, we are rejecting your prayer, but let us apply our mind. We'll not go by him. We'll see this. If whatever he has said is correct, there may be difficulty. Run the benefit. Yes, next.
Highly obliged.
We do not know how many other cases will be. Yes, next.
Analyst.
Huh?
Analyst file. Actually, his fault is he has published that file or the news of about the arrest of the husband of the informed.
Why we adjourn this time being? Use
So
them.
he wanted to see the video.
My lord, because that
Okay, okay. What,
Same, my lord.
what?
Construction mari wrongly done mari. You can say partner.
Translation, I even
Yes.
do not touch that paper.
Yes, I have seen my lord. It is not perfect.
gist of the case is that, my lord, there is a case, my lord, pending from the, my lord, son of the informant, man.
Hmm.
And for that
Yeah.
case, my lord,
Husband.
husband, man.
Husband of the
Husband-
informant.
Informant. And for that
In a
case,
POXO case, he is accused.
Okay,
case,
I have got it published in the portal.
okay.
Subsequently, this case was filed against me,
Hmm.
while saying that I have demanded some money, I have taken some money from her.
that
This
is
is the-
yes.
You might have demanded.
No,
I will
asked her
I
to
will not repeat this program, so give me the money.
Yes.
I have done it,
My lord, I
but
have
now I will not repeat this circulation. Give me the money.
the circle already done. He was already, I am the person who influenced her to surrender the court. That I did on my part. I asked her, you.
Yes. Do you need his custodial
This is
interrogation?
the only.
My lord,
Tell us, tell us,
only
tell us.
that much is the, my lord, in 164 he stated that, my lord, he took money for managing, my lord, that yes, this is the case, I will manage it all.
Already arrested manager.
That is,
He's all.
and that his money.
For the future, we will take care of this one. Nothing will happen, madam. I can assure you.
Considering the nature of allegation, material available on victim, with a condition, he will not indulge himself in any of such offences in future.
Right, true.
Don't, Mr. Chaudhary,
Madam, I'll-
don't
maybe
say
some-
about this
maybe they are not.
translation.
Yeah, construction
So
actually-
high English, we cannot even read. We go to the
That's why,
vernacular.
madam,
We read the vernacular.
Malad, here, Malad, I have talked with the Malad, second OC Malad. In another case, another BA listed today in put number 21, that case, there is fixed on 28.
Hmm.
I have not said that Malad today court is asking for any instruction or all this Malad. He is requesting for tomorrow, Malad, at least for
Can
tomorrow.
I just make?
Okay, tomorrow. Let him have this
No, no,
satisfaction
no, no.
tomorrow.
Well, can I just? No. I'm not seeking bail. Police mind. What the government says, diary is to be prepared by the. Let me just put. I'm not seeking bail today, my lord. It will be tomorrow.
You keep your energy for tomorrow.
My lord.
You keep your energy. List this on the prayer of learned additional public prosecutor. List this matter tomorrow in the motion column. In the motion column.
Highly obliged. Highly obliged.
Yes.
my-
Where is your doctor?
It's another court located.
Tomorrow?
The last item located.
Today we do not know about last item. Tomorrow.
I call him.
Tomorrow. Okay?
Yes.
You are there, you'll be tomorrow. Place this method. I get a photocopy for you.
Government.
Yes.
State
Okay.
of trust for the-
Yes, doctor is here. Or tomorrow. Any urgency? Tomorrow. We'll pass this order tomorrow. Two items. That both items. Yes, state. Ready?
Not
Appeal against Equitel.
Appeal against Equitel.
Okay.
Well, I can do one thing, my lord. If the lordship allows me, I can
Go through.
no, my lord, I can file one for written argument. It will have to.
Give it to him.
Yes.
Okay.
Let him. Because it's a 2009 does yes, my lord. Already 15 years. By Tuesday, I will send.
Okay. As prayed for by the learned additional public prosecutor, leaves this matter on. Not as per your convenience, give a date. 7th of December 2023. Full stop. He is permitted to file written note of argument in the meantime. With an advance copy to the learned
Yes,
counsel.
and I also mail it to.
If that is, it's very good. Yes, Ali, what is this?
Conviction under NIX, my lord.
Money paid, not paid.
No, my
What is the ground?
ground, my lord. The defense witnesses, my lord. They submitted, my lord, on affidavit. It was not accepted.
Defense witness submission affidavit. What is that affidavit?
Their evidence, my lord, in chief was submitted on the form of affidavit. It was not accepted, noting that this is not perfect. But now Supreme Court, my lord, set the guideline. Where, my lord, complainant as well as accused side, both can file, my lord, their evidence in chief on affidavit. The Indian Bank case.
Only that ground.
And
then what? How this it was dealt by the in the appeal by the learned session judge?
Session judge, my lord, this point was not discussed at all.
Have you raised this point?
The state court, my lord.
January will hear it on January. Be
My lord,
prepared.
my lord, we have also earlier discussed, my lord. If the matter, my lord, refer to, my lord, counseling, my lord, mediation, my lord, it will be better. My lord, what? Any date, my lord, in the month of
That mediation can be done after dismissal also, before you go to the jail.
What happened?
Isn't it?
Admitted, they have admitted everything. So
I understand. His only ground is that evidence. We'll look into whether he has raised in the sessions or first time relying in a revision. This is the issue.
legal issue that can be looked into by honorable court, my lord.
I will look into, but you are not ready. You could not say so us. You have waited for years. Just wait till the next year, January. Okay. 11th of January.
Okay.
Be prepared. Huh? If I ask some questions, you'll have to be able to answer. Give a data, this old method. Okay, somebody wanted to adjourn this. Why?
Yes, may I please, your lordship? Adjournment for the day because the engaged counsel for respondent is on leave.
What about the affidavit, Rajnish versus Neha?
Already filed.
File. You file?
We will file.
You will.
Yes,
They
we
filed.
will.
The earlier set of counsel they already
They
filed.
file already. So they have filed it. Now what? Why you want an adjournment?
Counsel is on leave.
Okay.
Short date maybe.
Okay. On the prayer of the learned counsel for the
As maybe.
respondent. Better stance adjourn and be listed on. This is maintenance.
Maintenance.
What is the current? You are for wife.
I'm for the husband.
You are for the husband. Is
For
there any stay?
No, man.
Are you paying?
I'm paying. Every
Okay, January. Huh? If you are paying,
Highly obliging.
okay.
matter came up before your lordship.
Why?
Hearing, my lord, but it could not, my lord, because of paucity of time, it was not taken. My lord, the IA may be disposed of, no case, my lord, apparent on face of the record. I'll come to the FIR, my lord. With all respect, my lord, that is at page 4, my lord. Here she tells a different story.
What is the sentence?
7 years only.
And 7 years.
Rep is, my lord, with all respect, my lord.
And how many days you are inside?
1 year, 5 months, 14 days.
Where is the FIR?
FIR page 4, my lord.
Page 4 of the appeal memo?
Exactly. Paper book, I'm sorry.
Where is the paper book?
Paper. Here she tells a different story. 164 she tells a different story. Evidence she tells a different story. And regarding rape, my lord.
Have you bought that contradiction?
Yes. Proved before the IO, my lord. Page 4.
Page 4.
Page 4. Here marriage is complete. I'm reading it. With due respect, I beg to submit that about 4 years ago, the Minu Sharma so-and-so tricked me into falling in love with him with a fake promise to marry me and raped me thereafter. As he raped me, I became pregnant, but on the 313 gone.
The person arrested and then he was arrested. Now, police filed the F. It was not the BT. Police filed the, one of the police informant filed the F, saying that the police party was on the spot at that time. Then they got this person. One person ran away. One person.
Anybody from the police examine?
Yes. Police,
that is just them.
Their statement.
And what is the stand of this this other 3 person?
This person independent.
In the evidence, this is their stand.
This is the, I'm coming on the evidence, not on from the 161 or 160. I'm coming from the evidence because this is already a conviction.
In the SIF?
No, in the SIF cross everywhere. They have indicated that they were the persons who caught this particular accused. So they have got the accused, brought to the office of the VDP. The 2 president and secretary got him brought to the VDP office. In the VDP office, the 3rd member was also called. He came, and the 3rd member was also the I think Caesar with. He was called later. Police version and their version is totally different. And
so you want to say that basic fundamental, what is the quantity?
Quantity, your lordship.
Are you ready?
Quantity.
Tell me. It's a serious case, NDPS. And if whatever he has said is correct, then if the foundational fact of that, because there will be a presumption.
It is tablet, your lordship.
Suppose for that presumption, you will have to lay the foundational fact that in this place, at this time, these are the materials that has been seized from his possession. Moment you release your burden, then honors will, it is his against him the presumption. But basic fundamental fact you will have to prove it. Are you ready?
Then lordship.
Because we do not want to have 3 starting halfway way going and come. There is no question of coming back. Do one thing, Mr. Mannan. Give me the copies of the Caesar witnesses. Mark it here.
I'll mark it there.
You mark you mark it. This will not be possible in this way.
I'll mark. I will give the VTP, Caesar witness, and the police. All the 3 I'll mark.
And kindly go through it. What is this? I do not know. These depositions, I think, in type copy format.
There.
So this is your one ground that conscious possession is foundational fact of conscious possession is not laid. Then what is your other ground? That is
the ground. Mainly that is. Secondly, the Caesar part, your lordship. I have also alleged the Caesar part.
Who was the
42 not complete.
Who was the informant? Informant was examined as PW?
PW, I think 1.
PW1.
PW1.
PW1 is the informant. And who was the
SI?
SI. And who are the Caesar witnesses?
Caesar witnesses are
PW2 and PW4.
2 and 4.
2 and 4. They are only the Caesar witnesses.
And even 2 and 4 are VDP part.
And according to them, they have first says and they informed the police.
Yes.
Then police came. And according to police that we are on a Naka duty or something like that. Then
We have-
we
we-
got
yeah.
them, then these people are near, we call
got
him
them
as a
and
witness.
they have given.
Witness.
I'll mark it if your lordship wants.
Marking is there, just I was searching it, but I've got it. Madam, go through it.
Yeah.
That is the only issue. If that be so,
Then the Caesar part 42 not come. That's the only, these are the only, these two. Because if first point is clear, then even lordship will not need to go to the second.
and other part is that 42,
Not come.
that sampling and all, sending it before
Yes,
the magistrate.
How
take-
they have the sampling done, sampling should have been done as per the guidelines already given. That is, these are the
Section 52 or 42?
is 40,
42.
43. Not 40, because
Sampling is 52. And what about this
no,
43?
this is the Caesar part. How they see, how they have
Okay, so your basic thing is that the conscious position is not established.
not established.
That is your case.
There is case, there is a difference. The evidences of the person are totally contradictory evidence on the basis of
So
contradictory.
therefore there is a
And
doubt.
secondly, 42, 43 is not.
Okay, if you have some judgments also keep it. Will take. Yes, madam.
Yes.
Where for you we are adjourning it, so that you can properly assess this court. And if anything in your favor, you can squash that even after, even if assuming that these defects, either you will have to argue that no, there is no defect. It is established. We have discharged our burden of foundational fact. Now it is upon, shifts upon you. What is the section? I forgot. And other part, suppose we say that this is not fatal for this case. These two parts you will have to satisfy, go through this PW 1, 2, 3, and 4.
Yeah.
And others also, then argue. Okay. Give it
Mainly
a-
1, 2, 3, 4, 5. One is an FXL. That is nothing.
that will come later on to whether it's this is
The required, but they have also
moment-
filed an affidavit. Objector.
Yes, sir.
They have also filed.
that's right.
That is on record. Objector type.
Yes, today I don't have the.
That's why I could gather from here only that you are briefless. Huh? No, be prepared because this is, see, many people are inside. On last occasion, I decided the NDPS Act. Absolutely no, you are there? No, that is to bail.
No.
That
Yes.
one appeal before vacation, I think we have decided that who was there? Forgotten name. Same situation. That is not there, and that lady was in jail for 9 years, almost 9 years. And after 9 years, we gave her acquittal. So,
Yes.
huh?
I-
You are not there.
I remember. If pending.
That was NCB. Mr. Kyle was there. 2011 it is pending. That 52 basically those things were there. Yes, when this is the opportunity to argue.
Fifth December.
5th December possible mostly. 19th December. Okay. I think we will be able to finish the list.
This part, because if your lordship goes through the record, can assist your lordship on it. Lordship can dispose of the whole matter.
That may be also instead of writing. We'll
That
see.
one, everything will be
Yes.
over rather than
Yes.
writing I and then. Anyway, matter.
Yes, for the appellant.
Yes, sir.
You are on bail.
Yeah,
High spending. Okay, on the prayer of the learned counsel for the petitioner, method stands adjourned and be listed in the month of January 2020. Okay, Mr.
Yes.
Is present, representing respondent number